Well, hello, Lyric Armstrong here, your real estate agent and advocate. We have been looking at the Dee Warner trial that is in probate. It's relative to matters that would concern her business affairs, her assets, and how it's going through the probate process when she was deemed missing for a great period of time. I think it's been 2 years. And I know that a couple of the attorneys, the petitioner attorney, has tried to put forth the detective to determine that, in fact, she was murdered and the person of suspect is her husband. So the last hearing or the first hearing we got into dealt with production. There was a order to produce documents that didn't transpire, so they were held in civil contempt for violating that order. And that would be Dale and his partner Weisberg. Now we're back. We're back. We're hearing closing arguments for the criminal contempt. The criminal contempt is in relation to Dale being accused of when he created the whole new company. So his defense to that was, I needed to create the company so that we can continue business as usual and avoid taxes. Oh, yeah, tax evasion. That's not a crime. Okay. But the problem is the court did have an order that said, do not diminish the assets of the current company, do not transfer monies of the current company. And what happened in trial, we were able to see in the last couple of videos. And in fact, he took assets, physical assets, furniture, equipment, and used that for the new company and didn't pay the old company any type of purchase. There's no bill of sales on any of that. And quite honestly, one of his witnesses got on the stand and said he was questioned with, well, what was the difference between the old and the new company? Did you do different types of services? Do you have a different clientele? He's like, no, we did all the same services. And no, we did all the same clientele. And he tried to argue the clientele was loyal to him as an individual and had no loyalty to Dee or her company or Dale and his involvement, that they were willing to move from one company to another based upon this other individual, the witness. Okay. Then it's like, okay, well, what did you tell them? Did you tell them that the old company had dissolved and was no longer in business, and therefore that's why it was going under a new name? And it's like, yeah, basically, I just told them we were going to be a new company and to, make payments out to the new company. Okay, did you do it in writing? No, we had that over the phone conversation. So, yeah, as far as I'm concerned, evidence does not look good against Dale. Looks like Dale and Dale specifically. I don't know how Weisberg is really tied into the transfer of funds and creating the new company and being nefarious against the court order, but he might be wiggled in. So we're going to get closing arguments today. I don't know if we're going to get a ruling today, but we will soon find out how the court feels of Dale deciding that he should open up a new company, no longer work the old company, and collect money through the new company and tell no one about it. Yeah, he told no one about it. They found out. They found out through the grapevine. Okay, so do those wonderful things. Just a little light work. I don't want to overwork you. I hate housework myself, okay? But we're just going to clean up a little bit, keep things a little tidy. I've been seeing that you guys have been doing a great job at sharing the video and getting more people informed. So thank you for that. Let's keep that up by sharing, and subscribing. This is a forewarning. The content of this case can be triggering for some. Oh, wait, gotta do my business too. Gotta make sure I like the video too. So it could very well be
Warner, file 22.
It could very well be a little disturbing for you. So protect yourself. This has to do with DV. We have a missing person who is at this point considered murder. I don't necessarily know if this court, the probate court, has taken that, but that's what the detective is testified to, that they are looking at a homicide case, and Dale Warner is the person as a suspect. He's no longer of interest, he's a suspect. All right, let's get into court. We're ready for court. Court Judge Catherine, and I don't even want to try to do the last name. I hate it because you'll be like, that would have upset anyone. I think it's Selah. I believe that's what it is. But nonetheless, we're in her court in probate in Lenawee County. So let's get in.
52433 ML. We are resuming proceedings today for purposes of closing arguments on this file, on this petition. May I have the names of our participants, please?
Good morning, Your Honor. Todd Flood on behalf of the petitioner.
Good morning, Your Honor. Ariel Berger here on behalf of Dee Warner.
Suzanne Wilhelm, GAL for Andrew Warner.
Michael McFarland, attorney guardian litem for Dee Warner.
Morning, Your Honor. May it please the court, Larry Lee on behalf of Dale Warner, who's seated to my right. Dale Warner.
All right. Any preliminaries before we get?
You can't hear me. Sorry. Weisberg is not even a part of this hearing. So the charges for this particular hearing, which is contempt of court on criminal charges, not civil, because the civil charges, they did that before and he was found guilty right along with Dale. And they had to spend time in court. And that was because of certain documentation and access to documentation was limited. But here, with the act of creating a whole new business, it's only Dale had to stand up as the defendant. So Dale is there by himself on this one.
To our closings. I have nothing, Your Honor.
I have nothing, Jen. No, thank you.
Nothing.
What's wrong with closings?
Nothing.
I have nothing, Your Honor.
I have nothing, Jen. No, thank you.
Nothing.
Very surprised to have that, Judge.
All right. That'll be it. Mr. Flood, whenever you're ready.
Thank you, Jen.
Oh, okay. Okay, she was just asking, can we go on to closings? And they're like, no, yeah, of course. So that's what that's about.
I had started off thinking about this for the last time since we broke, Your Honor, and I tried to come up with Dee Warner and who she is, who she was. If you go over here to Adrian College, there's two women. Both of them were foster kids from farmland over by the Thumb up north of Deckerville. Edie Buffett and Betty McDonald. Edie Buffett, 5'2", is in the Hall of Fame at Adrian College. Graduated right around the war. She was my godmother. Betty McDonald, parents died young when she was right around 13, 14.
Okay. Before you go to sleep, don't go to sleep. He is adding people that are not necessarily a part of the case. It's okay. You can pull on a lot of things. Right now, as a closing, you're trying to pull on the hearts and the minds of the fact finder. Right now, it's just the judge because they do not have a jury trial. It's a bench trial. And so, or at least for this particular hearing, it's a bench hearing. And so all these other conjectures about his aunt and whoever godmother, I don't know who you're talking about. All those people that he's talking about, it's hopefully going to wrap around to what makes the difference in regards to Dee Warner's life and the fact that she's not going to be around to be somebody's grandmother or whatever have you. Or that she's no longer able to be in an active role as a grandmother because she's not alive. Whatever he gets into, just as long as he doesn't misrepresent the facts of the case or inserts facts that were not admitted into evidence, he should be okay with kind of going off a little bit of the beaten path relative to what the case is about, because he should bring it back together. So don't go to sleep. Give him a little leadway. He's getting started. He's a pretty good attorney. We probably will like his closing.
Foster home. Went to Adrian. The two became inseparable. They were amazing women.
House is full too.
I thought they were,
Okay, sorry. The courthouse is full. I haven't seen the courthouse this full. Usually it's like four or five people on the first row, 3 people here and 1 person in the back, and maybe a couple people over here, which they don't really show this side of the room that well anyway, because as you can see, the way the camera cuts everything off. But I have not seen it this packed for the last, I don't know, 4 different hearings. So people are interested, so go ahead and stay abreast of it. I usually speed people up when they're this slow. I'm not going to speed him up because the mic is hard and his articulation is a little difficult when the mic doesn't pick up everything. So I want us to be able to hear it. So just, hang in there.
that lost generation of women
Try not to interrupt too much.
that we just don't see often. And I came to find out they're all around us. It's a matter of seeing them. And that generation lost, that greatest generation, that was Dee Warner. I call her the first responder.
All right.
That's what I call her, the first responder. Why do you say that? It's funny, you made a comment, Judge, it stuck in my head when Chuck Bullock testified. He's just more qualified or better qualified than the other people that had just testified. He's an expert fiduciary. And we had just listened to 3 people testify. And every single expert in this world always relies on facts. They always rely on the soul, the person, the human being, the heart. That first responder was what came from those 3 first witnesses. And they painted this picture of Dee Warner. And one thing that was simple and clear in the testimony from those 3 witnesses: communication, faithfulness, and always there. The love of that lady for her children, for her to like say to these kids, to this family, walk through every single one of them and say, I'm gonna leave them. Judge, if you love someone, if you have a heart and you have a soul, walk through these people. Walk through each one and say, I gotta say goodbye to them. I'll leave. That's not a first responder. That's not someone that went to a massage, if you go to, and hey, I gotta have my phone next to me and I gotta have it on if my family calls me. Are you kidding me? That was her DNA. And that was her environment. That was the lady that was there for all of them. And there's no way she's gonna leave a baby. Did you hear the testimony of the facts, what experts would testify about, what Chuck testified about? Because Chuck Bullock testified, I wanted to find out what she was like. I wanted to get to the family. And that's what he based his opinions on. Her baby girl and her were inseparable. They were together constantly. So if you're going to walk away, walk through that soul, that love. Facts dictate cases. Every time you teach a class in law school, every time you teach something with regards to law, you always want to focus in on facts. Every single person of those lay witnesses that came up and testified, from, get this, when Amy testified, and she testifies, I don't want to be here. I got a connection to Dale because I'm the fiance of his brother. But she had the courage to get up there on that stand and said she's dead. And she said she'd do it for me. I'm willing to risk my home life because my family is connected to Dale. But to simply say, and she could have turned a blind eye, she didn't. She didn't turn a blind eye. She said she was always there. And what was amazing was, remember the scene? Do you remember the picture in your mind's eye when she goes there on that 24 and she picks up the child? How does she describe facts? How does she describe Dee? That fateful night, that night ultimately where it was to her demise. She says, I've never seen her that way. She's a tough woman. Don't get me wrong, she's a tough woman. She had ailments. And we'll get to those. She had migraines, headaches, back problems, knee problems. She had it all. But she's a tough woman. And I'd never seen her when she'd been crying, when she'd been watched out. I'm calling it quits with Dale. I'm calling it quits, Dale. Not that I'm leaving the world. I'm calling it quits. Never seen her like that. I know on Sunday, I'm trying to get a hold of her, she says. I'm trying to get a hold of her. She's always up. Habits, Judge, evidence, habits. She's always up on that Sunday. She goes to breakfast. She does her family stuff. What happens? What happens? Can't get a hold of her. Cal goes later on. Hey, you see my mom? I'm supposed to meet her at the diner. Right? So that's not her. It's obviously clear. Who comes up next, Judge? And we can get into the domestic violence. We can get into the bruises. We can get into the evidence of the fact that there was beatings that took place on this woman before. Facts, but let's just go to the witness testimony of the.
Okay. Oh, he's doing such a great job. I didn't want to, listen, I want to, pause and talk, right? And I'm doing my best not to, just because I don't want us to lose the effectiveness that he is having. But I just also wanted to point out this activity here. The last couple of videos, we weren't really able to see Dale's reaction to a lot of the facts that came in because he was cut off. Like, I didn't like that. We talked about it, whatever, I'm leave it alone. But we can see him now. He did not like the fact that the attorney just said bruising and domestic violence, because what came into the court as evidence was that there was the detective was able to say that he can represent that there was evidence of her being abused and having domestic violence. And I don't necessarily know if they were able to get into evidence that the cause of the domestic violence was with Dale, that he was actually the perpetrator. It is the alleged belief, but not necessarily a factual basis, because he hasn't been convicted of it, okay? So that's why evidentiary hearings and things of evidence and rules of evidence are so critical, because finite things get kicked out if they are not able to be proven. So I think he wanted his attorney to object, and the attorney shook his head. This is me guessing, because the attorney said domestic violence was committed. But the attorney was good about not saying that Dale committed domestic violence. The attorney said that the woman have evidence of her bruises. The woman has evidence of her beatings, that she had experienced domestic violence, but he didn't say by Dale, that Dale did this to her. So he kept that part out. And I think it was because of the evidence that came in during the trial part of this hearing. But anyway, just kind of pay attention to what Dale does, because this will be our first time really seeing his responses to the things that are alleged against him.
Second witness that gets into the stand.
Facts are.
But there was beatings that took place on this woman before. Facts, but let's just go to the witness testimony of the second witness that gets into the stand. The competent, no one's impeaching her. She lost her husband. Who was there? First responder. Don't you want a friend like that? Don't you want a kindred spirit like that in your life? I surely know I do. Who's there? Dee. Because everybody, you lose your husband, you lose your spouse. You know, it can be uncomfortable. You know that as well as I do. It's common sense, right? So people shy away from you. Not Dee, first responder. Girl, I'm there for you. Let's go. We're going to lunch. I need to be out, Dee. Can you come take me? I got to have some human reaction and socialization. Dee's there. Describe Dee with the dog. Inseparable. How's the relationship? Very powerful. It doesn't take more than common sense to know Dee's not leaving that baby, nor this life, nor this world as someone that is there as a first responder. Go to the massage therapist. I just did the math last night, and 40 times a year, weekly massage, 5 years, 200 times. 200 times. Judge, you ever see somebody 200 times on a religious basis over 5 years? Guaranteed. That's remarkable. That's a pretty telling story. As Hopkins would say, everyone's got a story. That's a pretty telling story, right? See that person 200 times, 5 years, and talks about the bruising, talks about that, but not only did she see that person 40 times 5, 200, she also talked to her on a regular basis. She talked about life. She talked about how passionate helped raising her younger, because her children were younger. She talked about how devoted and dedicated and the habitual steps that Dee would take to be there for everyone. She was the connective tissue. As I said in the opening, the evidence would suggest or point out, if it comes out to be true, it came out to be true. She was the connective tissue to this family that brought everybody and was there for everybody. So experts rely on, judges rely on facts. Clear and convincing evidence is that for which the allegation to be true, it is clear. The United States Supreme Court, the Michigan Supreme Court, probate courts, believe it or not, have more cases for burdens of proof than any other circuit court or district court, except for getting your driver's license back. But every court, probate courts have the most cases with a burden of clear and convincing evidence. You just have to look in all the journals, and it's always in re when you want to establish that definition. In re. So what is it? Based on facts, the evidence is heavy, it's weighty, it's clear. There's no rebuttal to the evidence. What witness, what morsel of proof do you have in here to rebut the weight and avalanche of the clarity of this testimony and evidence? There hasn't been one. Now you get to, on that day, we brought in Mr. Bullock. And why? Why was Bullock so important? Why was Bullock so important? Not, he established water's wet. He established the elements necessary for why this, in his opinion, Dee's dead. Dee Warner's dead. No one with her passion and her drive, as you learned about her, wants to give up her baby of business to some stranger. Her money and how she spent it and how hard she worked and how much she spent. No one wants to give that up to Chuck Bullock, he says. And every step and point he went through was that there was not transparency and there was definitely obstruction of trying to figure out where the dough rate, where the money was. And I knew I was going to get the answer. He didn't know, and you heard it. There was about $150,000 he couldn't find, and I used the phrase basically that was a pimple on an elephant's tuchus, and he said that was a rounding error. Well, we put an arrow in that, and you can button it up. And I'm not going to get into the Michigan State Police testimony at this point, but Michigan State Police trooper in charge of this case on the criminal side of the fence said, no, we found it. We found $140,000, and that was in a credit card that accounted for that money. So, but Mr. Bullock comes in. Now, it's clear in every criminal prosecution, when you prove a cold case in something similar to this, in probate courts as well, you always look to the cash, follow the money, follow the money, follow the money, follow the money.
Your Honor, I'm going to object at this point. This is not a criminal case, and for Mr. Flood to allege that this is a criminal case, I think is beyond the facts that have been produced here. This is a petition to determine death, and I would.
Well, I appreciate that. I have a lower standard, thank goodness, but I can go to the reasonable doubt, but I don't have to. I've made an analogy in this closing argument, Your Honor. The analogy is, in this particular situation, you follow cash. And here, the expenditures by Dee Warner, and you got the Yo-Yo reports, you got the expert testimony or the fiduciary testimony, his capacity as a fiduciary, that's how we qualify. He can testify and give his opinion that she's dead. But the point of it is that there has been no expenditures of money since that day of April 25th.
Okay. The objection of not wanting the probate court to take the criminality as a factor, it's honest, it's not a criminal case, but it's an actual reminder to all that you don't have the standard of a criminal case. It's not beyond a reasonable doubt. It's going to be with the preponderance of the evidence. So, what are you doing? He could have left that objection alone, in my opinion, because we are looking at criminal contempt. That's the hearing. It's regarding criminal contempt. So there is criminality to the matter, and it's the fiduciary concern, and so the counsel wrapped up why it was pertinent. But one of the things I noticed throughout most of the hearings, there will be objections to the floor, and there's very seldom an audible decision by the court. And I see right now that even the attorneys just continue to go, and you don't get the objection rule on the court. So if you don't have the objection ruled on the court, how does that work for appeal? Put it in chat or put it in the comments. Let me know how you think that's going to work for appeal. What are you going to be able to appeal upon if you don't have a judge's ruling on half of the objections you put on the floor?
How do you survive? Follow the money.
And I guess if the evidence still comes into play, then you can say that by the actions or the inaction, it proved that the ruling was overruled or something. Maybe that will be the way you'll have to, quote it in the appeal. But it just makes a person wonder. Like, I would want my objection ruling on the record so that I can point to what the ruling actually is versus having to surmise and give summation to the fact of what the ruling is.
There was no export of cash from the state prior to pay for Dee Warner to live, to survive. Follow the money, follow the facts. No money. How do you survive? Bring out and buttress that testimony with the expert that comes in, and I shouldn't say expert, I'll say the Michigan State Police analyst, who is highly educated. But Judge, the electronic footprint for which you leave, I leave, Mr. Lee, anyone in this room leaves, except if you still have a rotary phone and no cell phone, everyone has a footprint. And everything as it relates to travel has a footprint. Everything as far as what we see on cameras, from either the ring cameras, from the cameras on the road, to eye recognition, to lean information, to national information, to world information, not a blimp on the radar. What, all the evidence, you have all the exhibits, you've seen this first responder has never shown up in any footprint of travel. The fact of the matter is, when you listen to her and the depth in that exhibit, it's 3 pages long, and we went through all of the material that she went through. There was not one scintilla of evidence, not one piece to show that she was alive after April 25th. I held the deputy actually to last on that first day of that June date we had been here. And the deputy that came in here established for you, if you look at the statute in B and C, one of the things that it says within the statute of prima facie evidence of death is that of a missing persons report. You have it. I put it up. I put it up on the screen. I paraded it around for 3 or 4 different times. We don't, but a missing persons report is enough as prima facie evidence of death under C. Or disjunctive, you can prove, if you don't have that, you can prove death by circumstantial evidence or by establishing the burden of clear and convincing. Circumstantial evidence, Judge, as the jury instructions, and as you have tried a plethora of cases, and as an evidentiary issue, we look at circumstantial evidence, and it's right there in the jury instructions. You can presume that it's raining outside if someone walks into the room here and has an umbrella and takes the umbrella, taps it, there's drops off, a raincoat drops off. You have enough evidence to show that it's raining outside. Although you didn't see it, although you didn't hear it, although you weren't outside. That's enough, even in the highest standards of the world, to prove. Here we just have to have clear and convincing evidence. So the deputy, I asked him, is this some willy-nilly thing you do? I mean, is this something you could just write up, don't have to get permission to write up that missing persons report? Remember his testimony? Oh, no. That goes through a higher chain. I have to make sure I get approval for that. That's why that standard's there. But what I think was telling, when that deputy was there and on that stand, and you heard him, and he was clear. And he had taken Reed test, that's the training and interviewing and an investigation of interrogation, the 9 steps he knew. He said he wasn't getting what he believed to be truth from Dale Warner when he was out there. He said, he used the word deceptive. But what was clear, no vehicles were missing. No transportation, extra transportation was there for Dee Warner to escape in. He says she's dead. The deputy, based on his investigation and his knowledge of the case. But proving water's wet sometimes difficult. But in this situation, the facts, there's no evidence that there was someone that came and got her. There was no evidence that a car was missing, in fact, opposite. There was no information as it relates to any camera sighting, an investigation done of inside or outside the road from that house or into town or to another location where she was picked up, if that was even possible. But Dale says some things to that deputy that are troubling. And you remember them, right? For example, we had an argument previous night. She had a migraine. I was going to be up with her all night long. But she talked about suicide. Dale said that to the deputy. Put it in the report. Talked about suicide. Really? Why do you bring that up? Why do you bring up death? I wonder. Right? When did you last see her? 7-ish on the couch. Really? Calls around 7:30. Phone's going dead to automatic into, by all accounts, from the family and the first three witnesses first two witnesses trying to get a hold of her. Goes right to voicemail. Never had that. Right? Curious. Gonna be up? No, wasn't up with her all night, so obviously that wasn't true. Second, migraine. Third, talked about suicide. Why do you bring up death in a case like that? Doesn't take a rocket science, and we don't ask common sense to be checked out at the door. Those statements are statements that obviously put into the mind's eye of Dale or of Dee Warner being dead. So, Judge, as you well know, Mr. Warner took the Fifth Amendment, would not testify in this case. And so what you, as a court rule, must presume is that everything he would say would inure to the benefit of the petitioner and the side as it relates to our benefit. If he, since he didn't take the stand, the court rule is clear.
Your Honor, I'm going to object to what the Fifth Amendment says. It's pretty clear that Mr. Warner has a constitutional right.
Judge,
and that overrides everything that we do in this court, including Mr. Flood's ridiculous comment that taking the Fifth somehow aids or abets his case. That's ridiculous.
No, so we're not in a criminal courtroom, but he's citing a criminal thought. We're in a civil courtroom, and civil cases, when a person takes the Fifth Amendment, and unless there's something I hit my head on today coming into this courtroom that changed the law, when you take the Fifth in a civil case, everything that would be said has to be inured to my benefit. That's a simple rule that's been written from the beginning of time in the civil courtroom.
I'm just making this suggestion, Judge. This is not a criminal case.
Well, then don't bring up a criminal rule.
You brought up the Fifth Amendment, which is a right against self-incrimination.
Well, we're in a civil court, Judge, not in a criminal case.
Thank you for acknowledging that.
Duly noted.
Thank you. So you have to use everything that would have been said, would have been inured to my benefit as a petitioner in this case, since he did take the fifth in a civil proceeding. It's that simple. That in and of itself, plus the testimony, plus the prima facie evidence of the missing persons report of the first day, establish clear and convincing evidence that Dee Warner's dead. Go to the next, and I want to get to a point where you see the Michigan State Trooper, without equivocation, walks through the health records, the money, the banking, the eye recognition, the credit reports, the lien, law enforcement identification network, the fact that he walks through Secret Service to see if there's any global travel, international travel, or domestic travel. He testifies to those reports. He testifies, Your Honor, as it relates to not only those simple things, but as it relates to any morgues, any hospitals, any Jane Does, all of the things you would require to establish death. He put in evidence in front of you. There is, without question, an unequivocal, and no way you can penetrate the fact that he establishes through all of the physical evidence necessary that Dee Warner is dead. When you take the man hours and he added it up and gave you this number from the federal government to the local government to the state government of law enforcement and forensics that were put into this case to find and prove the negative, he established for you all of the necessary requirements that Dee Warner was murdered. And he said, Dale Warner is the suspect of it. The key to his...
I'm going to object again, Your Honor. He never testified that she was murdered. He testified that Dale Warner was a suspect, but there was no testimony that she was, quote, murdered, close quote.
Oh my God. Oh my, that's exactly what he said. He said she's dead. We believe her to be murdered, and Dale is no longer a person of interest. He is the suspect in a homicide. What are you talking about?
Once again,
Read the testimony. Read the testimony. I have the transcripts right.
That's interrupting his closing argument. That's why you get a closing argument. The only time, I guess this particular objection is like the only objection that really matters because it's pertinent to what the evidence was, but the objector is incorrect. That the evidence was very clear and concise. The gentleman was very serious. The officer got up there and said, no, she's dead. She's murdered. Dale is the person of suspect. And we have an open case against him. Oh, Lord have mercy. He's working. Okay.
Is the suspect
Go
of
back.
it. The key to his...
I'm going to object again, Your Honor. He never testified that she was murdered. He testified that Dale Warner was a suspect, but there was no testimony that she was, quote, murdered, close quote. Once again,
Read the testimony. Read the testimony. I have the transcripts right here. That's what he says. And we can go through it. It's closing argument. If he wants to rebut it, he can try, but it's in the testimony.
that's fine. I will object.
It's in the testimony. If he does, but at the end of the day, the bottom line is
Tell him.
every single, and Mr. Lieb can try to get around the impossible, but there is nothing as far as the man hours that have been put into this to show Dee Warner, who has ailments, Look at the prescriptions. She's on several medications. The CVS prescriptions that were returned and never picked up. Look at the ailments of the neurologist and all the other therapy that for the comorbidities she suffered from. None of those things. Blue Cross Blue Shield, no insurance. Her phone, she has not used her phone from that fatal day of April 25th. There's not a second phone as he proved it up because he checked and looked for a second phone. Remember the testimony of how he traced through that? There wasn't proof or evidence of a second phone. It was clear. There was nothing that was left or a rock unturned. He got them all. And he went through all those exhibits. If we had to go through them again, we could. But at the end of the day, you heard the testimony. The testimony from his standpoint of his law enforcement and homicide investigations, she's dead. And this is how he did it. And he shows that missing money was not missing. In fact, it had been spent. So when you take, obviously, when you take the law enforcement and the man hours and the power of their team into this, and you have postings that are put out in the national attention this case has received, no one has spotted or tipped that Dee Warner is alive. And no one in this room objects to that. Mr. Lee doesn't object. He's withdrawn. None of us object. The evidence is clear. It's the difficult part, Your Honor, and I started off with it as Dee Warner's the first responder. Gail talks about she would never have left me in a position where she wouldn't see the birth of her granddaughter. She's there to make sure that her family was taken care of. She was there to make sure that her grandchildren and her youngest were loved. No one in this room is going to object that she's dead. The evidence is so overwhelming that there's no hesitation for you to decide the declaration of death. You follow the money, you follow the physical evidence, you follow the facts. Experts like Mr. Bullock, Fisher, he leans on witnesses. Law enforcement leans on witnesses plus physical evidence, direct evidence. We have now direct evidence by that of showing she's dead from all of the technology in this world for which we have. We have circumstantial evidence from all of the facts. We have the presumption that she's dead based on the missing persons report. So I end for where I began. No one as a first responder that sacrifices her life for others, that gives to others, is going to give up her child. She's not going to walk through these people and let them go. That's not what her heart, DNA, and the evidence in this case show. So, Your Honor, I ask you humbly and with great deference and respect because you've been, and I thank you, one of the best as far as reading and seeing and having this, in this case, sitting over it as a pro. There's nowhere in this body that you can point to that would give you doubt as to what we showed here. And I ask you to find by that standard, Dee Warner's dead. Thank you.
Thank you. I'd like to go next.
Okay, before we get into the next closing argument, I want to clarify. So the very last hearing we had on this particular case was the hearing relative to the criminal contempt charge or allegation against Dale for starting up the new company. And so when we saw closing arguments today, I thought, oh, great, we're gonna get closing arguments on this so we can get this settled. As you can hear from closing arguments, this is actually closing arguments on the declaration of death. So a video or two ago, I'm like, why are we still calling her missing? We were, you know, she's deemed dead by legal standards. We've already legally found her dead. Turns out they didn't have the closing argument on it, so it hasn't been founded. So now I have clarity as to why they kept going back to between missing and dead. Like it was a whole thing, a video or two ago. So that's what that's about. All right. It's heavy. And this particular attorney did a phenomenal job, in my opinion, in giving us the emotional pull that's necessary in a closing argument. He was very quiet, reserved in the beginning, and then he gets into the heightened expressive side. And of course, we got Mr. objecting all over the place, which the last one of his objections made sense to object because it was relative to what the evidence was presented in the case. However, problem was he's mischaracterizing the evidence. We were there for that. We saw what the evidence was. Man said it was dead, which is the reason why I thought they'd already deemed her dead because we had a whole hearing about how the detective said, she said, we believe foul play, murder, that she's been murdered, and Dale is a person no longer of interest, but actually the suspect to her murder. Like, how clear could it be? But there is a massive truth to the fact that very finite words can make the difference in the statement. So if he doesn't say that she's murdered, if he doesn't say that Dale is a suspect in the murder, and all he says is that she's presumed dead and Dale is our suspect, that in and of itself are two different things, because murder is dealt with intent. It could very well be, what's the other one? Manslaughter. Like, you're dead, but it's by an accident versus murder. So that could be arguable. So we'll have to go back and see what were the detective's exact words, because that's about the only objection that he gives during the closing that really has some teeth to it, even though he does irritate me. Spoiler alert, if you haven't seen this before, this particular attorney irritates me. He irritated me before I even knew the facts of the matter. Like, we were having some kind of evidentiary hearing in probate, and that was like so simple and great, and he was irritating then. And now I kind of see why he's irritating, is because he's not fighting just probate. He's not fighting just for financial security of his client and nefarious acts relative to finances. He's also protecting his interest in a criminal manner, because there's an open case against him, and that which is used in this case could be used against him. So he's irritating, but he has a reason to be. Okay, let's get back into court. Okay. Let's get back. We can do it.
Court Order. I stand before you today, Judge, not asking for finding of guilt or innocence, as we're all aware.
but asking for a finding that accurately reflects the evidence that has been presented to you. Not only as the attorney for Dee Warner, but as an individual that has grown to genuinely care for her family and her friends, I'm asking the court to make a finding of death. I wish that my client were here for me to get to know. And I wish that she were here for her children and her grandchildren and her siblings, but the reality of the situation is that she's gone from this world. I've been told that I'd have loved her, that in some ways I'm like her. And after getting to know her through her friends and family, I'd like to take that as a compliment. There's been an abundance of evidence presented to this court that, in my opinion, clearly meets and even exceeds the requirements set forth in this statute under 700-1207D. This overwhelming evidence has led every witness you've heard from to bluntly state that they believe she's dead. Not that she's gone, not that they don't know where she is, but that she's dead. And who better to tell us something that they know to be true, that they know in their hearts, that they know based on financial evidence, based on their professional opinions as data analysts and investigators. Who better to give us this information than the people that were closest to her in life and closest to her after her disappearance? This isn't a woman who is out in the community. This isn't a woman who would be living off of the land somewhere. Not someone who's climbing palm trees to chop down coconuts and have a tasty snack in the afternoon on her new beach life. This is a woman who, above all else, put her family first, always. Who, even in attending sessions with her massage therapist, which generally people use those to relax in, she had her phone on, she had her iPad on. She was stopping those sessions to answer phone calls to make sure she's still in contact with her family. Someone who, even when she was having a disagreement with her husband or someone else in her life, when she would go spend time with another family member or go spend time away from that situation, would tell people where she was going, would reschedule missed appointments, would let her professional relationships know that she was going to be unavailable for a certain period of time. This woman went out of her way for her community and for her family. She reached out to individuals she knew were struggling in their most time of need, to her friends or acquaintances rather, who became friends, who experienced a loss that none of us can even describe. When her personal life got a little too much for her, she told her family she was done with her marriage. This wasn't her saying that she was done living. It wasn't her saying that she was done being the person she was at her core. That never wavered. All of this evidence, Judge, has convinced me that my client is deceased. And I understand that this is a weird position to be in, that I represent someone who's not here or who can't tell me what she wants. But as I've listened to the testimony, as I've helped gather it, as I've interviewed witnesses, it's led me to believe that there's no other possibility that this woman could be alive. This evidence has convinced her family, it's convinced her children, her friends, and Judge, I'm asking that you find that it has also convinced you. Thank you.
Beautiful, beautiful.
Okay, thank you, Ms. Berger. Who would like to go next?
Okay. Before we get into posing, okay, he gives me so much anxiety. I'm sorry. I'm human. As a legal-minded person, we're taught to think critically, to be objective, to see both sides, and then try to see if there's a different side, and to get all these unknown elements. Just one, so that you can identify them. Two, if you can disparage them if need be, or three, you can, exploit them to potential defenses and so forth. So I have that in mind, but as a mother, I have five. I don't know if you know this. I have 5 children, and my youngest is still a young buck. Not a little younger, but not too far off from when Dee disappeared. Her child was 9 years old. I'm just not doing it. I'm not leaving her. Not to say a person doesn't leave the marriage, but I have in my core, I have a hard time believing that she doesn't leave with her child. So the first picture of this is what she does. She goes off and she runs away, and then she comes back. So there's really no reason to stress about it. She'll be back. She wasn't back, right? And Dale is not the person who called the police. It's the daughter. So as the husband, and I didn't even hear this part before. So as the husband, he believed that she had communicated to him that she had suicidal concerns and thoughts on that day, whether it was something she was dealing with ongoing. I'm not getting into that. I'm not her health professional, but on that day. So on that day, he says, so I was not going to leave her side, but yet you don't know what happened to her, according to you. Yet you don't know 7 o'clock where she was. You weren't leaving her side. Call up and how do you stay? I mean, I've stayed up, overnight and then worked during the day and then came home and crashed. But honestly, you don't call up a couple family members and say, look, we need to take shifts and watch mom because she's giving me some very high concerns. So we don't have any evidence of that. Okay. She left no note. Okay. The phone incident. Okay, so the phone thing that came up was a major thing for me originally because he talked about how the phone is still active. That number is still active. It's never been inactive, but he ported the number to a new phone, like very short time frame after her so-called disappearance. So she didn't have an active phone to make a phone call for in distress or pick me up because she didn't have her car either. So she didn't have that. And so the reason he gave is because he needed the phone number because that's where all of the business was coming from. And I've told you, I'm a business owner, got several businesses. You don't have to just port the phone. Yeah, it's easier, but you have your clientele list. Of course he did, because when he sold the business, he sold the clientele list. So you have your clientele list and you send them a notice and say effective communications needs to go to this new number. So simple. Put it up on your website. It becomes so simple. I liked that the petitioner's attorney had a theme, first responder. It's a very wonderful theme because it means that she is the resource for her community. And it's highly unlikely that the resource of your community is, going to disappear and, not resurface, knowing that the community is dependent upon her in some way. And both attorneys just gave like the paint the victim, understand the victim, understand who she is. First responder was the first theme, and the second attorney who just came up was the attorney for Dee in representation of this particular claim is also kind of echoing that same first responder element, that you're not going to just miss your grandchild's birth. You're not just going to all of a sudden no longer be there for your grandchild, because the first grandchild she was babysitting during the time she goes missing. And that anytime she went missing before, or anytime she wanted to take a break, this is not missing. If you're taking a break from someone or a break from a situation and you're having a vacay, I mean, we all need them. We just probably don't take them when we need them. Dee is known to call everyone and say, look, I'm going to be here at the lake house. I'm going to be there at, the resort or wherever for the next couple of days because I need to decompress. So she's a communicator, a very communicator as to where she is and when she's going, and a reasonable time frame that she believes she'll be there. And that didn't happen in this scenario. The communication stopped that night and she called no one after the fact. Shortly thereafter, Dale changes her phone number and so forth and so on. So anyway, that's what we got from their closing arguments. The two attorneys in the background behind them are the guardian litem. One is a guardian litem for Dee because they believe Dee is somehow, if alive, incapacitated and can't speak for herself. That's the lady, if I get this correct. It's one of the other. And then the guy maybe it was the lady that's the guardian litem for the child. But either way, these two guardian litems cover, one for Dee and the other one covers for the minor child who's around 11 years old now, 9 years old when her mother went missing. Now, every woman, men, you may not get this, and this may not be your thing, but just trust the woman's perspective. Every woman needs a woman that they can confide in, beginning especially at the age of 11 to about 14 and 15 years old at the absolute earliest, and maybe later, because you're going through hormonal changes, you're going through developmental changes, and the hormones are playing on your mind in terms of how you perceive things, how sensitive you are to certain things that you weren't necessarily sensitive to before. And then you have your menstrual cycle comes into place. You have a physical change in your body, and then your development physically changes, and you have the result of soreness and change and weirdness and oddness, and you need to be able to have an outlet and communicate. And so a young girl typically does that with their mother. There's no indication that this young girl and Dee were not close anytime before. So one would suspect she would have been the one that her daughter would confide in. She's not here for that. I do not believe a mother, whether they're escaping an abusive relationship or not, I don't believe the mother would leave a child behind knowing the vulnerability they're putting that child, especially if they're leaving them with the abuser. So it's nonsensical to say she left on her own volition and nothing nefarious has happened to her. I almost feel like I don't know why Dale picked this particular defense, other than the defense of, she was fine when I saw her. I don't know what happened to her, but you're right. Since she hasn't been back, this is abnormal behavior on her part. So please help me find her. I don't know why he doesn't have that kind of response. I get this response like, well, I know where she is, and she must be alive somewhere, living her best life, doing what she wants to do. Oh, and then that thing about living off the land. Dee does not present like a woman is going to live off the land. She was not the farmer in the company. And she loved her jewelry as much as I didn't like the location she was buying it at. She was buying her jewelry and her nice things, and she was used and accustomed to that. So and she was the person, the breadwinner in that regard. She was acquiring these things through her own financial ability. So I just don't understand any defense that, oh, now she's off in the wilderness, off the grid, and that's why you can't get a hold of her. Yeah, okay. All right. The defense gets to come up. Let's go back to court.
Your Honor, good morning. On behalf of Dale Warner,
That we don't know. What we do know, though, is that it most likely does not amount to beyond a reasonable doubt, or we would have a murder charge. And we don't have that. So we do know that. We don't know what the evidence is. He is a professional, and he is on this case, and he has been on it for a long time, and his opinion that she is dead will be given the weight that it deserves by the court without knowing what exactly it's based on. We simply can't know that. So, but it still does count. In conclusion, Your Honor, I'd just like to say that I know that you will make the right decision in this case. And whatever your decision is, I know it will be the right one. I only wanted to take this opportunity to point out what evidence I don't think fits in the case, but what evidence does go towards showing that she is in fact dead and not just missing. And I do think petitioner has shown a lot of good evidence in that respect. Thank you, Your Honor.
All right, well, thank you everyone for your closings.
Your Honor, I have a brief statement.
Oh, Mr. Boulderman.
Oh, Mr. Polderman, he is off Zoom. Yes, he's in the court. Can't wait to hear from him. He was very spicy when it came down to where's the money, where's the money. He was always on Zoom. So right now we'll hear from him, but just want to go back. Okay, so Dale does not object to the petition. The petition is that she's dead. Their whole fight is how is she dead? They don't know. They don't know how. Stop trying to say he did it. He didn't do it. So that was refreshing to hear that was his position. I still am irritated by that attorney, but that was redemptive in my opinion. I appreciated the fact that he was not trying to argue that she's not alive, even though during a lot of the trial, you would presume that was his argument because of his objections and all of his assertions during that time frame. The illusion that he was trying to prove that that Dee was alive. Okay, so sorry I had to deal with the front door and I ended up not hearing it, all of it, but I went back and listened to it while the guardian litem got up, the gentleman. The last guardian litem, she had me concerned. If you saw the petitioner's face during that time, he was like, well, what is she trying to say? And what is she? So she had a hard time getting to her point of the facts, but I think, like she said, she is healing from whatever illness she had because she wasn't at the last two hearings, I think it was, because of her illness. And so the death timeline was what she was talking about relative to 700, 1207, and 1208. That's relative to when the court can deem in summation, like they can just come to the, they must be dead kind of equation. And I think it's a 7-year total, but she was talking about the 5 years is when after 5 years of non-communication, then you can get into that point in Michigan court. But she did a whole lot of that, and we know that she's at least missing because the evidence shows that, and then she finally gets into what shows that she's dead. She bases that on the diversion of assets, the fact of the wedding ring being present, then no longer being present. Of course, not taking any of her personal effects, money, no car, no nothing, no phone, activity, and then fact that Dale was not communicative nor helpful in the process of determining, what's going on. And he was hiding things, and there had to be a lot of show cause motions to go forward to get the evidence they got because he was not turning things over. So he wasn't cooperative. And then, of course, the detectives witness testimony that she's dead. As far as we're concerned, Dale is the suspect. So, but she went around the bush to get there. And I was sitting there going, what is she defending? Like, is she defending? Is she not? Like, so her presentation was a little bouncy, but she got to the bottom line at the end. So at the end, we find out she does support the petition and she does believe she's dead. So great. All right, Polderman's up. I'm excited. Let's see what he has to say.
You might want to put your appearance on record.
Good morning, Your Honor. John Polderman on behalf of the successor conservator, Charles Bullock. Your Honor, I know the court has heard the evidence. We have not taken a position in the ML case. We don't have anything to add that hasn't already been said. I would just note for the record that if the court does in fact make a determination of death under the statute, the conservator is obligated to think in the words of the statute, hold the assets until a personal representative is appointed. That could be a 42-day process or even longer. It's unclear as to who the PR would be. However, the underlying conservatorship involves an active ongoing business. The conservator is involved in reviewing budgets weekly. We have an active business court litigation in front of Judge Olsaver with deadlines and discovery and motion practice and depositions and a trial coming up in January. So to the extent the court does make a finding of death, we would also like an order entered that the conservator can continue in his current role until a personal representative is actually appointed. So we're not in a gap period where all we can do is just hold assets but not actually administer them or be involved in the underlying litigation.
Thank you.
And nothing further, Your Honor.
Thank you.
All right, Polderman's in person. And as he has been in the past, he is the money person. He is money central. So he just wants to make sure that there remains a conservatorship, there remains someone in place that will keep an eye on the assets. And that's a reasonable request because we noticed that Dale was moving money in the middle of trial as it were. So that's great. All right, so it was simple enough. I just wondered what he had to say. So
And Mr. Flood, this was your petition. Did you want a
Interesting.
final opportunity to make any comments?
I think everybody has stated it well. I'm glad Mr. Polderman did notify the court as it relates to the personal representative visit. The grace period of 42 days and that he be allowed an order entered if you do find that we've established it, that the business can be ongoing and not stall off. I think the great weight of the evidence, Your Honor, has been simply put in front of you as it relates to the trooper that came up and testified. He answered all the questions. As far as the murder goes, that for which he did not disclose, and it is not sacrosanct that they're not prosecuting this case, and that's not how the procedure in the criminal justice system may work. But all that being said, I think everybody's in the same page and same agreement with that we've met our burden.
he says it, but he doesn't say it. He says it, he doesn't say it. He said, so this is where having the benefit of a bench trial will work in their favor because the judge has been an attorney, so she hears the nuances that's being said. But when you're in a jury trial, you need to be like direct and complete and exact because you don't want them to interpret or feel like they didn't hear you say it. And he does say everyone's in agreement that she is dead. That's the petition. Is she alive? Is she dead? The petition is that she is dead, to deem her dead. And everyone is interpretive, really. I mean, I could say everyone, and you can think everyone in the whole wide world believes it, right? Or in this trial, you can say everyone believes she's dead, and you can say, well, everyone on that side of the table believes she's dead, because automatically in your brain, you see two different sides of the table. you see two different sides of the issue. You see the petitioner and the respondent. So in essence, you may hear plaintiff defendant. It has that same kind of role, if you will, but it means differently. Petitioner means they're petitioning the court. They're not doing a civil proceeding that is a claim that requires a payout or an injunction. So they're not necessarily a plaintiff. They're a petitioner that's saying, we want you to put in an order, put it to rest, this issue. We want you to decide it upon an issue. And so they petition a court for that. And instead of being a defendant, because they're not being accused of certain aspects, which if you listen to the trial, you would think Dale is being accused of killing his wife, right? And that's what the whole case is about. This case is probate. That particular allegation and accusation will go through a different process, which is usually criminal court. So they are petitioning and Dale is responding, right? He's responding to the petition. So a lot of that is paperwork. You get motions, responses to motions, briefs, it's a lot of back and forth with legalese, arguments based upon, facts of the case, right? So blah, blah, blah. But if you are a juror, you're in your mind, petitioner, plaintiff, defendant, whatever name you come up with, you see two sides. You see one side that has all these representatives, 2 guardian litems, 2 different attorneys. You see another side. At this time, it only has Dale as the respondent. At one point, there was another respondent and his attorney. That's what you see. And consequently, you see them on 2 different sides of the court, and you presume they're on 2 different sides of the issue. And so when you say, attorney, petitioner, we all agree that she's dead, there's going to be a presumption that the we that you're talking about are the people that are standing there with you who have joined in on the petition. And so the judge understands that his we is not just us, it's we, everybody here. Because if you remember, when Dale's attorney came up to the podium, he spoke about, we agree that she's dead. We just don't have nothing to do with the fact to say that Dale did it. We don't know what happened to her. Something happened to her, but we don't know what it is. And obviously she's dead, because she wouldn't be gone this long. We agree to that, but we don't say it's Dale's fault. And everybody else says, yeah, she's dead and it's Dale's fault, right? Or at least Dale's acting like we can presume it's his fault. That's how the facts have played out. I just wish when he did his rebuttal closing that he just would have said, Your Honor, I would like for you to take judicial notice of the fact that all of us have agreed to the petition. The respondent has rescinded their objection to the petition, and in closing argument has agreed to the fact that the Dee Warner is dead. So consequently, we're in a spot where there is no necessity for you to decide upon if she's dead or not, but just to agree with all parties, both respondent and petitioner, that she is dead and put in the official order so that we can proceed with the probate as needed for the deceased. He doesn't say that in those words. He did it a different way. I'm sure she understands what he meant. I just would have liked a little more descriptive and decisive statement. That's just a little of me, my opinion. Who cares, right?
Thank you. I'm going to take the time to read back through. I know we have a couple of transcripts that have already been prepared, including the testimony of our witnesses that testified from the different departments that have been investigating. So I will be taking the time to review some of that, as well as my own notes, and I'll be drafting a written opinion on this particular aspect of the Dee Warner matters. We do, of course, have our next Dee Warner case scheduled to begin at 10:30, which is the show cause on the criminal complaint. So at this time, court's going to recess, and we'll be back on the next hearing at the
Judge, any time frame?
I'll have it within a week.
Okay, thank you, Your Honor.
Court's in recess.
All rise, please.
Thank you.
I see.
I think this is the longest court.
Great. Yeah. Good, I want. So, I start another one. October, so. Yeah. Yeah. Oh. Yeah. You are.
Okay, so they finally cut the feed. That is the longest I have ever seen her feed go. Usually before she hits the gavel and she hasn't even exited the court, the feed drops right at that moment. And this is kind of the reason why we've talked about it before. When you are in court, let's get into what, because let me show you. There was a couple of things that kind of stood out in the during the break, if you will, because they're in break. Actually, they're going to go into another hearing, which is what I thought we were hearing today, was the criminal contempt. Turned out we were listening to closing arguments on the declaration of death. Okay, one of the things I noticed, here's Dale. I didn't see anyone in this audience come up to him. And I don't know who the people are in there. I mean, I surmise these individuals in this corner over here are the children, the adult children of Dee Warner. Not sure who these people are, if they're spectators or if they're family members. And if they are a family member, if they're his family members versus Dee family members, don't know. We don't know. But I didn't see anyone put a pat to his shoulder. I didn't see anyone give him consolation. Maybe you saw, but I didn't see it. And I thought, wow, it almost gave me some empathy for him. Now, obviously, I have a personal feeling that he's the cause of this. I don't know if it was an intentional thing because, you know, she came home and said, I want a divorce. I don't want to be with you anymore. And he said, ha, you leave me by one way only, you know, till death do us part. There's no other part that's allowed. I don't know. Or if it was, you know, an argument that, you know, ensued and he physically got violent and it went too far. I don't know. I don't know. I wasn't there. Can't attest to any parts of it. But just being a human being and seeing, because it's abnormal. I mean, I've seen rapists that have, you know, family members, friends, some type of support. It doesn't seem like he has any support, at least not visible during this period. So I was like, oh, that's interesting. Like everybody is like, you did it. I guess except for his co-defendant. They don't believe he did it, right? And some of his witnesses don't believe he did it, but they weren't visible to me during this time frame. Okay, so we talked about court. All righty, so let's get into what we're seeing. This here is the jury box. If the jury were here, this is where they would be seating. Multiple seats along the side is the jury box. There are some courts that the jury box will be on the opposite side. This is this area here. Consequently, the way it goes is the petitioner, the plaintiff, and in criminal matters, the state, whoever is bringing forth the matter to the court is atypically sitting next to the jury box. The reason is because the defendant who's sitting across has better, the jury can better see the defendant when they are in this section under most circumstances. Obviously, if the attorney is sitting and blocking the defendant, it'll be a little harder, but atypically, it gives them the ability to see the defendant during all times, which is why I have that issue with the Zoom where the two are together and Dale is like falling off Zoom, or they have some kind of filter on it that makes it fuzzy and you can't really see his face half the time. Is because if you were a juror, most of the time you should be able to see the defendant because they're across, and that's the idea. So here we have the well of the court. Right here, I want to say he was the bailiff. He might have been the clerk, but I think he was the bailiff because I think he's the one who gets up and starts asking everyone to take the oath. So, you know, to swear the witnesses in. So I believe this is the bailiff. The court reporter should not be too far behind. And of course, closer over to the wall is the judge's bench. This is the well of the court here. And so when you'll hear a lot of attorneys, not too many attorneys right now because they're doing closing arguments, period, but you'll hear a lot of attorneys ask if they can approach. And some of that approach request is to approach the podium because it's in the well of the court, or if they're going to be approaching towards the jurors, and the podium would typically be turned that way because they're going to be the finder of facts. Since the judge is the finder of facts for closing arguments, the podium is pointed towards her way. If you needed to, you know, give up documents to the judge or present something to the judge, you get permission before you go across the line and get into the well of the court. Otherwise, the deputy is going to get up and have issue with you, or, you know, at least slow you down. So that's what that's about. This right here, a lot of places have like a sliding, swinging kind of door. I don't see one here. It might be behind this chair, like turned all the way, but typically it closes right back after. So I don't necessarily see one here. We call this different things. It could be called the rail. It could be called the bar. I just say, you know, where the swinging door is. But this here is a stopping point as well for the general audience. This is your general audience. And depending on how the court sets up the general audience, if it's a really involved case with a lot of individuals, then they may say the first row is for the legal team, second row is for the family, and the rest of the rows are for the general public. Or they may identify the maybe the second row for the journalist or the, whatever. So it depends on how the court wants to control some of the general audience elements. Looks like the family was able to sit on the front row. And that the legal team kind of stayed over here with their desk area. Maybe some other individuals were part of the legal team, people back behind there, don't know. There was nothing definitive to that. This camera makes me think that this is the news outlet, and the lady that was operating it makes me feel like she's the operator for that. That's what I think. It's not definitive. I didn't look it up. I wanted to show you just, this is what I'm talking about. When you come into these doors, there's, in the very beginning, there's someone who has to unlock the doors. There's usually the bailiff. And they're ensuring that you come in and you have a seat in the general audience section. And that if you are an attorney, you get to cross the bar. So you pass the bar, which means you pass the bar exam for your state. You're allowed to practice law. And then you can go into court and cross the bar here, which is the rail, cross that, and then come sit to your respective area. If you're on the respondent side, you're typically across from the jury pool. And if you are on the petitioner or, state side, criminal plaintiff side, you are typically right next to the jury pool. So that gives you an idea of which one of the tables you're supposed to be at. So that's a little bit of that history that we were talking about, give you a little breakdown of what's there. And then you always got to get permission to get to, or you're supposed to always get permission to get to the podium. Judges can be loose with that, but just ask anyway. Just ask, may I have a permission to approach podium? And then you present there. The petitioner, he kept his notes kind of on his desk. He didn't bring them to the podium. Most of them, I think he had them pretty much in his mind anyway. And you saw him do a lot of walking. Even when he got close into the well, he didn't leave the side or the area of the podium. It's not like he just started walking up to the judge area. So when you are presenting your closing argument, if you're presenting your closing argument to your jury box, you can walk alongside the jury. Some will get to that like rail part there. As long as you're not jumping into the jury box or, being aggressive and offensive, it's usually okay. But if the podium is set in a usual space, it's very seldom that the attorneys will fly all over the jury box area. But it's a part of getting engagement from the jury, keeping them entertained enough that they're listening to what you have to say. So there are some physicalities to your performance. So when I said general public is not allowed to walk around and just, hang out and just go in any which way because you have a bailiff here at the front, and then you will have a bailiff making sure that whoever crosses this rail, aka bar, is in fact someone that's going to be sitting at these particular tables. When it comes down to closing and opening arguments, you'll see way more activity. You'll see way more, movement from those attorneys. And that's okay because they're doing what they're supposed to do. And it's the attorneys, is not some random person from the audience. And then he was walking back here a lot. He was highly audible, so you could hear him when he was walking back here. That's the attorney. He is not audible. His articulation, his pattern of speech, all of that is just like, oh, I wish he had like a lapel mic that just would follow him because like I wanted to hear what he had to say when he got here to the end. That's why I was like hanging out, because when we did this in Judge Middleton's court, we got a lot of insider information from one of the litigants just by hanging out to see what they were saying after the fact, which is one of the reasons why I think this particular court shuts the feed so quickly so that you don't have the ability to hear in case there is a live mic. This desk has a live mic. The petitioner is moving his stuff around and banging up against the desk. You can hear a lot of that because his mic is live. And this gentleman comes up to make communications with him. Sounds like they're coming to some type of agreement. I don't know if it's going to be for later on's hearing or what. Because he's like, okay, yeah, okay. But we can't understand what he's confessing or talking about. They leave, and then the petitioner and the guardian litems come and speak to 4 of the family members. And I'm surmising that these are the kids. Those 4 family members that are here would be the adult kids anyway, because the 5th child is a minor and most likely not going to come to these hearings. I wouldn't expect that the guardian would recommend that, because to see their father in this position is not to her benefit. Okay. No one says anything to Dale. No one turns around and they look at him. Everybody else is ignoring him. Excuse me. And I know that this lady, I believe, is the petitioner for the family, for which this attorney represents them all, but she's the one who brought the petition up, I believe, the older sister, the older sibling. Not sure which one of the gentlemen or Zach, because they didn't show him when he testified. But anyway, that's where we are. Our normal hearing for the day will happen a little later, waiting for the court to get out of recess, and then we'll be able to see the civil contempt. Okay, so in this particular hearing, we had a lot of objections. It's not the civil trial. We're not held to the civil standards. It's not a preponderance of the evidence. They are held to clear and convincing. So it's clear and convincing evidence for this particular matter, which is the declaration of death. So a lot of fight on that, but we will be hearing criminal contempt. Same courtroom though, same judge. So this is going to be very interesting to see what is going to happen here, because they did their closing arguments for that hearing already. And so now the judge, I believe, is doing the order. I believe that's what we're doing. I believe, because like I said, I got sideswiped. I thought that's what we're doing now, and turns out we're doing closing arguments for declaration of death. So we'll see. Let's go ahead and take our break. Like, share, and subscribe. The lightest housework there is. See, I love it. Like, share, subscribe. Doesn't really, you barely lift a finger. You just put your finger here, put your finger there, put your finger here, and you're done, right? Oh, I love it. I wish it could be that simple. Where is Bewitched? Maybe we can get Bewitched on the planet, and then they can just go around our house and wash our dishes and everything with a twinkle of the nose. We're not that simple yet, but as far as like, sharing, and subscribing, we can do that here, and that's the light work of the day. So let's do that. Get ready for our break, refresh ourselves, and we'll be back soon. All right. Have a good one. Lyric Armstrong, your real estate agent and advocate. See you at the next video.